Yesterday, prosecution asked court to give them permission to amend the charge sheet, of which they wanted to introduce new charges against the 4 co-accused in the alleged murder of the late Henry Katanga, which happened in November 2023. And at the beginning of the court session, the 4 co-accused pleaded not guilty to the new charges, and these include being accessories and also destroying the evidence. Court was meant to make a ruling on whether the widow Samali Katanga could attend court proceedings via Zoom, that is from Luzira prison where she is being held. And prosecution accepted that that can happen for as long as it's her choice, but her lawyers must formally make such a submission to court.
To be made. My Lord, an application has been made to this court. There is the inherent power of this court to meet the ends of justice. The prosecution has just told you, my Lord, that they do not intend to oppose it, save for 2 areas. The Constitution is very clear, particularly Article 126 of the Constitution.
When the nature of the prosecution witness requires her physical presence. My Lord, in that regard, we will pray that we will accordingly inform court and require that the prison authorities produce her physically.
The defense lawyers complained that prosecution indicted the suspects before receiving the DNA results, which should be the basis of the evidence to charge them. And thus, they say, it tantamounts to prosecutorial bias, which culminates into prosecutorial fallacy.
Therefore, my Lord, would need Samali as a witness, Samali Wakoli as a witness, come and explain where she got the facts.
She says, for all the other things requested, we are unable to deliver as they are not in our possession, and we don't envisage relying on them during the trial. So my Lord, they don't envisage relying on documents which were the basis of charging the accused persons.
The defense has no right to summon any person as and when they wish. Their right to determine who should be a defense witness is restricted by Section 75 of the Trial on Indictments Act.
She is competent, she is compellable, and A1, A2, A3, A4, and A5 require her in that dock.
However, prosecution argued that the Deputy Director of Public Prosecutions cannot be subjected to a law that governs the advocates.
She may be practicing the regular practicing certificate, but she must be enrolled as an advocate. And I imagine that my colleague is actually enrolled.
This application has been brought without any legitimate purpose, and it is just intended to waste a very valuable time of this court.
Justice Isaac Muata will be making a ruling on the 9th of July on the subject matters that were raised during the court proceedings. Sudhir Byaruhanga, NTV at the High Court, Kampala.